mother's behavior. But on the other hand, they also wrote about being very upset that the visit supervisor lost sight of the mother and the children when they were on paddle boats, and the paddle boats went around a bend as if, there was some real concern something terrible would happen during that minute that the paddle boats were out of sight. There was also evidence in these diaries that the foster father compared the mother to a terrible case in New Mexico where the child had been killed. There is nothing that was ever presented with regard to the mother that suggested that she would be violent or physically abusive in any way to either of her children. And the court did not take into account this view that the foster parents appeared to have of the mother when deciding that visits should be totally at their discretion.
Was there evidence that the mother, and I might be mistaken, but was there evidence that the mother had struck the child with a spatula in the face?
Your Honor, I am not recalling anything like. There may have been an allegation at one point. It's a voluminous record.
Try to blame me. They switched it. They said a wooden spoon and then to a spatula.
An isolated incident. As you're aware, the primary allegations had to do with the failure of the mother to protect the child from sexual abuse. The case revolved around not allegations of physical abuse. So in terms of the law on post-adoption visitation, adoption of RICO makes it clear that when the child's best interests require, the trial court is not just entitled to issue a post-adoption visitation order, it's required to do so. Now, there is an exception set forth in Alona when you can be sure that the pre-adoptive parents will be acting in the child's best interest. But I would say that the trial court just didn't make findings on this matter and had evidence before it that the foster parents had a somewhat skewed vision of the mother and very little evidence that they would promote such visits. And I think, in terms of the child's interest, in some respects, a post-adoption visitation order would really help separate, the worries about how the foster parents would react once they were adopted parents, and, would have a clear and regular order that everyone could abide by that would promote some regularity and consistency in the visit order. And it is important to note that once this case is over and it's terminated, the child will not have counsel anymore, and the adoptive parents will be completely in charge. And in those circumstances, there really will be no recourse if the adoptive parents decide it's not in the child's interest to see the mother, and the child wants to see the mother, but she won't really, and the mother will be completely out of the case, and there'll be no real recourse. So I think at the very least, this case should be remanded for findings on post-adoption visitation. But in addition, there are issues with the termination itself, which of course has to be supported by clear and convincing evidence. I think here...
Mother concedes she's probably unfit, right?
Fuck you.
Well, the mother, at the time of the trial, said that her position was that she was currently unfit, and that return of the child to her care would not be feasible until there had been some family therapy. So really that was the focus of the trial, whether the mother's situation was so ongoing that...
Why doesn't she tell them that you have your son?
That it would be unable to repair that relationship between the mother and the daughter through family therapy. And in that regard, I think that there was an error by the judge where he failed to consider all of the evidence. a review of the evidence and the transcripts shows that there were really two portraits of the mother. The first is the one adopted by the trial judge and promoted by DCF, where the mother was hostile, she was uncooperative, made no progress, continued to make bad decisions. But there was a second portrait presented by the mother's service providers, which presented her as quite cooperative, having to deal with a very traumatic past of her own, but willing to work on issues, showing growth, showing commitment to her daughter. And I think at that point, with these two portraits, the court was required to determine which was accurate and should have noted the observations of neutral observers. And there were two successive court investigators, plus Dr. Rutherford, who did a neuropsych evaluation, and all of these parties, neutral parties, not taking a side in this case in any respect, were troubled by the conflict between the mother and DCF.
Ultimately, it's up to the trial judge to conduct the ultimate resolution of those conflicts, and the trial judge did that.
Well, it's of course up to the trial judge to make that judgment, but the findings should reflect that the judge considered all of the evidence, and I would say here the findings don't reflect that. For instance,
but why? I mean, they don't have to inventory all of the evidence, and the mere fact that the portrait that the judge
They're
ultimately
Luciferians.
settled on is not the one that you wish he had, doesn't mean that he didn't.
well, I think, Your Honor, it's more than that. I think that the findings reflect a concentration on, the so-called bad facts about the mother, and an exclusion of good facts about her. And adoption of Stewart says that, the findings have to reflect that the judge considered these so-called troublesome facts, and factored those facts into the decision.
Well, didn't the judge say that there's no question about the fact that the mother and the child had a bond, and that there was no question about that mom had pretty much complied with her service plan, and done all the things that she was asked to do? I think that's all in the record. The issue was whether or not she was learning from the compliance with the service plan, and I think that's kind of where the rubber hit the road for the judge, that they saw no marked improvement. The mother continued to coach the child.
It was impossible to record improvement.
To record what?
Improvement. There was no...
They just didn't see any outward appearance of mother improving.
What's the
And
word?
the child's now 12.
Measurement to prove.
Well, I think in that regard, so two things about
To
that,
gain
Your Honor.
insight on my
First,
trauma. How do you...
It's
measure
exactly those things
that
we
one?
note. Number one, that the mother had complied with the service plan, and number two, that there was a very significant bond between the mother and the child that make it so important for the court to look at all the evidence here. And then in terms of, what the mother was doing at the time of trial, the mother's visits with the child had been supervised and for years. And the mother had been specifically instructed not to talk to the child about any of these incidents. So while there were allegations that in the past the child had, or the mother, there were allegations that the mother had tried to coach the child, or that the mother had difficulty accepting some of the child's allegations. At the time of trial, it had been quite some time before the mother had even been alone with the child. And so I don't think it was an
I haven't
issue
been alone
of
with my child.
Not ever.
of the
Not
mother,
especially since they've been taken.
continuing to communicate to the child that she should deny the allegations. I think what the trial court found was that the mother, in its view, hadn't made sufficient progress because she didn't accept every single detail with regard to the child's allegations, and instead
It was here.
repeatedly testified, well, I don't know, I don't know that, and felt like she couldn't, she communicated that she couldn't endorse every detail of what the child said about her sexual abuse.
It was a rather, you say, an effort to evade the allegations, right?
Excuse me?
It struck me as though it was a fairly persistent effort to evade acknowledging that history.
Well, I don't think that the evidence can be read that way, Your Honor, because the mother did definitely accept that the child had been sexually abused. She
Had she been?
would not endorse
Before they were taken.
that the details
I
of
did
it,
all
but,
the procedures.
I believe that kind of what happened in this case
Into
is
the
that there was an
hospital, filed a...
over-focus on the details of every single allegation, because what the experts testified to was the important thing was for the mother to accept that the child had been sexually abused and to provide the child with support. And that was what family therapy was meant to accomplish.
That it seems to me, in looking over this thing, on the whole, for the child's progress with the mother, is probably the most troubling part, right? Because the child had the deeply rooted belief and understanding that the mother did not believe her. And that was, in terms of the progress that the child is going to need to make over the span of her lifetime from the trauma that she experienced, that may be the most important foundational factor of all, right?
Yes, but again, two things about that. First, the child, when asked, why do you think your mother doesn't believe you, said that other people had told her that.
Mm-hmm.
And because the mother's visits with the child had been supervised, it was not the mother saying that. And the second thing is that the mother's position was that family therapy should be tried. And that would have given a therapist the opportunity to meet with the mother, maybe for more than just one session, to really
never had a
make
session.
sure that going into family therapy, that the mother was going to communicate to the child that she believed her, that was the most important thing. And I think that that's where the courts needed to consider all of the evidence about the mother's behavior with her various service providers. Thank you.
Thank you. Okay, will the department or the child be going first?
The department.
Okay.
Thank you.
Thank
you,
he's
Your
the
Honor.
child's
Good
attorney.
morning. It's Andrew
Oh no, the
Batchelor
department.
on
That's the
behalf
child's
of the
attorney.
department. To respond briefly to some of the items raised earlier,
Mr. Batchelor, could you focus on this particular one? Isn't there record support that the mother called the child a liar and that believed that the child had continued struggles with telling the truth about some of the allegations that she was making?
yes, the record is replete with mother's struggles, and that mother refused to recognize the truth of child's allegations when the child made those allegations to mother. So back in 2014, when the child reported the allegations about father, when the child reported the allegations about the neighbor, both times the mother failed to believe the child. In fact, she went so far as to shake her head and discourage the child from speaking the truth about what happened, about what father did. She did that in front of DCF workers who informed the court of that. And mother continued to have an inability to accept the truth of the allegations long after that, and despite the courses she took and her parenting evaluation in 2015, that's finding of fact 51. Mother could not accept the truth of what happened then. In her statements to Ms. Webb in 2017, she again said that her daughter had been lying, and the court very carefully, although I agree with Justice Green, the court is not required to catalog every piece of evidence. The court
He revoked his license, his rights.
Ms. Webb and mother had
Father
different.
Yeah, he never went to
memories of
court
what
because he
happened at
revoked
that
his
meeting.
rights.
The
No,
court
no.
said that
The foster father. He doesn't live with
the
her
court
anymore,
credited
right?
Yeah,
Ms.
they do.
Webb's version of that interaction, that mother had said child was lying. And even at the time of trial, mother could not say that she accepted the truth of what the child was saying. When the court directly asked her whether she had any idea whether her daughter, in her mother's view, is lying or not, the mother said, "I don't know." She had no idea. And so it's just over the course of time, from the moment of the abuse up through trial, mother had a systematic inability to say that she believed the child, and there was no basis to hold out hope that the unfitness was only temporary. There's no reasonable belief it was only temporary. Therefore, the detailed facts show by clear and convincing evidence that mother's unfitness was not temporary. The court should be affirmed.
What do you say to the post-visitation or lack thereof?
I would say, Your Honor, that all of the facts given to you by Attorney Kaiser just now were also given to the trial court judge. And the trial court judge heard all of that, and finding of fact 149 found that the foster parents not only supported visitation, but said that visitation was critical.
Bullshit.
So
Why haven't I seen my daughter since March?
To weigh the evidence, weigh the different testimony, the trial court found that the foster family, the pre-adoptive family, did think visitation with mother and with brother were critical for child. Based on those facts, that the court's decision to not order child custody, child visitation, to respect the parental rights of the adoptive family.
Then why haven't you been seeing your daughter?
Exactly.
And was proper, should be affirmed. Also, very briefly, the court asked about a spatula, and that's in finding of fact 34. But I agree with Attorney Kaiser that was not the motivating factor, if you will, of the trial court's decision here. And it's really that inability to understand, to address, to even begin to acknowledge the full scope of the abuse.
He has nothing else to say. Look at it.
That I believe led the court to the conclusion it came to terminate parental rights. And the court was not focused on every single detail. In fact, as I went back to the transcript, I didn't see the court really pressing mother on any particular detail. The court just wanted to know if mother would accept that abuse happened by anyone other than the first babysitter, and mother couldn't.
Bullshit.
Gone over in detail in my
The mother
briefing,
couldn't what?
I won't repeat any of those.
Accept
here, and unless there's
any
further
of it.
questions from the court,
That she was sexually abused. Like, that's bullshit.
Thank you. For the child?
He's a fucking scumbag.
I believe I still have the last few seconds to say good morning. My name is Alan Campbell. It's my privilege to represent, and I'll refer to my client as daughter, in this matter. My client, the daughter, asked that this court affirm the judgment below in its entirety. I just have a few points to touch on. The first one is to
Veronica's attorney.
address the point made by my sister that mother just couldn't accept all of the details of the allegations, and that really simply isn't the case. Mother couldn't accept the allegations. Mother had allowed 5 individuals to sexually abuse the daughter. Paternal grandfather, or maternal
What are the 5 individuals?
Father, 2 babysitters, and a neighbor. Only as to one of those allegations did mother indicate that she believed it. However, even if that single one that she thought may have happened, she wasn't 100% certain. So
Fuck
there
you.
wasn't a single allegation that mother would
Not true.
say, yes, I believe this.
We even
100%
went for a SANE interview and everything.
And I'm sure your honors have read through the records. The case is replete with instances of mother referring to the daughter as a liar. During her testimony, she had a great phrase that she liked to use. I don't know that. She used that when asked whether she believed that the daughter had been sexually abused. She used that when she was asked whether she thought the daughter was a liar. She used that phrase when she was asked
What
whether it would be
phrase?
helpful
I don't know.
to stop calling the daughter a liar. I don't know. I don't know that. I don't know that. Mother, again, this isn't about the minutia. Mother simply could not accept that she had exposed daughter to at least 5 individuals who had sexually abused her. Mother did a great job of ticking off boxes on her action plans or service plans. However, she didn't benefit from it. At the time of trial,
You didn't fucking know
she
me.
was still unable to admit that she had put the child at risk. And that failure to admit it indicates that she would put the child at risk again if returned to her. As to the question of visitations, my brother did point out finding 149, where the judge found the foster parents, and I'm quoting, the foster parents feel it is essential for daughter to have a relationship with mother and son. And the foster family be willing to, and it goes on. So the court found that they thought it was essential, not just supported or open to it, that it was essential to do so. And also, there was an order of sibling visitation. The son is with mother. The order mandates that the foster family and mother will continue to have contact. And there's no reason to, nothing in the record suggests that they wouldn't go along with. The court also suggested that not suggested, in the order, the foster family is to consider daughter's wishes as to whether or not there will be contact with mother. And the judge found, and as is the case, daughter does want to have contact with mother. However, she wants to have it on her own terms. She doesn't want to be forced to have contact with this woman who, over a period of years, I believe we're now 8 years from the first abuse, has continued to deny that it happened and to refer to her as a liar. That is very, very hurtful for my client. My client
does the daughter want supervised visitation? Is that what I read?
Well, she wants contact, but she wants it on her terms. She doesn't want a set order where you have to meet once during these 3 months and maybe once during these 3 months. When she wants to visit, she'll tell her adoptive parents, who become her parents, I'd like to talk to mother.
Fuck you, that'll never happen on my dead body.
She wants it on her
Become
terms.
her parents.
And the suggestion that family therapy might help is not supported by the record. There was an effort at family therapy. In mother, as the judge found, mother used family therapy as an opportunity to explain to daughter that she hadn't been sexually abused.
Bullshit.
One could argue that could not have been more harmful to daughter. What daughter needs, again, is for mother to validate and accept and say, yes, you were abused by a number of people. I believe you. She simply can't do that. It's unfortunate. She had 8 years. The first abuse was in 2012.
You admitted that the daughter was sexually abused once. That's it.
Mother has since removed.
He's saying there were 5 people that raped your daughter, basically, is what he's saying.
Her that she was sexually abused. Time after time, she simply cannot do that. That's what this case is about. Mother is not able to provide the validation that daughter needs. Fortunately, since 2016, daughter has been with a wonderful pre-adoptive family.
Fuck you.
The judge found that they are able to meet that need. They're able to talk her down when she escalates, when she has behavioral issues. They provide her a safe home, a home that she wants to go to. And remember, daughter testified in this case. It's brief testimony on pages 161 to 178 of the transcript. But she was extremely articulate for a young woman in what must have been an exceptionally stressful situation.
14.
Wants to be adopted
13.
by the current placement. And if she had to leave this placement,
14.
she would rather go to a random foster home than be returned to mother's care. And unless there are any other questions,
Unless you hear your daughter say that, then that's all a lie.
Seeing none, that will conclude the argument in this case. Thank you all. Case is submitted.
Wow, they cut him off pretty quick. Still 1 minute and 51 seconds into his...
Let me just try to click on it again.
Yep.
Shit. Yeah, they cut it all off. They cut everything off.
And unless there are any other questions, I will rest on my brief.
Seeing none, that will conclude the argument in this case. Thank you all. Case is submitted.
So he's
DCF.
the attorney for
DCF.
DCF.
Yep.
He's the attorney for, oh man.
Veronica.
Veronica, okay.
So it's interesting how they stopped ahead of time. He didn't even finish, supposedly. I don't care. It's all fucking bullshit.